call and listen in. And he will present to us at our next meeting about prosecutorial decisions and ethics. So he apologizes for not being able to be live on Zoom. So I think the meeting is pretty much going to be run. Natalia's done some great work. She has some PowerPoints. We have some recommendations to go over. And so I will let her lead and become one of the members.
Sounds good. Thanks, Representative Mori. I'm going to share my screen. So just a second. Okay. Okay, are we good?
We're good.
All right. So today, our main goal is I want to review our bail and pretrial recommendation and vote on that. Also vote on our decriminalization recommendation if we are there. Check in with you all if there are things that you feel like we've missed. And then like Representative Mori mentioned, Jim was going to talk about his prosecutorial charging decision recommendation, but we're going to bump that to next time. Maybe we can get out a little bit early this time and add in, we might need to add in a little bit of time for our next meeting. But just a reminder with bail, so we had 2 meetings about this, and I think we came to consensus on a lot of different issues. So this is not a comprehensive list, but I just wanted to remind people that, we're going to be deciding between 2 recommendations, but they have a lot in common. So I think those were consensus ideas that we don't necessarily need to revisit. And again, this isn't comprehensive, but just wanted to review for y'all's, just as a reminder and for the benefit of anybody who's watching. Both of the recommendations, made a recommendation of around first appearance being within 48 hours or the next day in which district court is held. They both recommended preventative detention hearings within 5 days of secured bond being set. A lot of different recommendations around new responses to failures to appear, the need for independent pretrial services and better funding for those services, especially in either smaller or rural counties, and exploring kind of regional models for being able to offer pretrial services. Ending the suspension of driver's licenses on the first failure to appear, and improving statewide data collection. So just a reminder that there are those and other recommendations that are in both versions based on y'all's comments and the discussion that we had previously. So I just wanted to zero in on kind of the differences between the 2 recommendations so that you all could think about those and discuss them. And I actually can't even see all of my own screen, but the 2 differences have to do with how far we go with eliminating the financial conditions of release. So option A is more expansive. It eliminates financial conditions of release for class 1, 2, and 3 misdemeanors, with this exception that unless it's made apparent to the satisfaction of the court that there exists danger to another person or intimidation of a witness. And then, so all of the differences in the 2 options are encompassed within that first sentence or first piece of it. The second piece is what happens for defendants charged with felonies or class A1 misdemeanors, or any other defendants who are still being held on a secured bond. So it requires that before imposing that secured bond, the judge is required to strictly adhere to the already existing statutory preference for non-financial conditions, and then make an individualized determination that the person can either pay the bond from their own funds, or they're supposed to provide written findings that detention is necessary. And you can see kind of all of those reasons why it might be necessary. So I wish I could have put them both on the screen at the same time, but there was just too much text. But option B is similar, except for it separates the first section out into 2 different sections. So it's the same for class 2 and 3. It says eliminate financial conditions for class 2 and 3 misdemeanors, unless there's danger to another person or intimidation of a witness. But then it separates out class 1 misdemeanors and gives the additional exceptions. So it adds in the risk of a defendant's flight and the prevention of destruction of evidence. So that's kind of nuanced, but you can see that option 1, goes farther in the elimination of cash bail, and option 2 is a little more limited. So that is what I have, just to kind of refresh y'all's memory, and I'll open it up to discussion on which one of those 2 options you want to present to the task force.
Thanks, Natalia. And if Jim's not able to call in, I think from our discussion, he was more in favor of the option B, not to include all class 1, 2, and 3 misdemeanors without any possibility of imposing bail. So I think that was his voice and why we have these 2 options, and wanted to present them both. So anybody want to talk about it?
So, Representative Morey, I'm in full support of option A. I mean, there's no relevant reason why money needs to be an issue when it comes to especially these misdemeanors. We've already got a bunch of qualifying reasons that a judicial officer can look at before these individuals are released, if that were to happen. But possession of drug paraphernalia or possession of stolen goods, which are class 1 misdemeanors, that should be no different than a simple assault. It doesn't make sense to me why we wouldn't include class 1 in there. So I would be in full support of option A, which is where this task force needs to go, especially because of the benefits that people will be able to keep their housing, hopefully their jobs, when they've been charged with these criminal charges. I mean, representing people, my own personal experience from representing folks with misdemeanor larcenies in the past. I mean, if they've been accused of a larceny, money is obviously an issue. And us keeping them tied up in our criminal justice system isn't going to help them. There's other ways we need to help them. So option A would be something that I'd be in full support of.
Thank you.
Representative Maury.
Yes, sir.
I'm also in support of option A. I've seen too many times people go into the jail system for a week or several days, and they pretty much lose everything. And most of us are only living off of one paycheck from the poorhouse, and you find individuals that, and then a lot of times they're incarcerated for those number of days, and they end up being innocent. So, how you go back and make those changes, most of these employers, they want you there. If you're not there, then they'll replace you. And like I said, I'm all for option A. Thank you.
Thank you, Commissioner. Tara?
Yeah, I tend to agree. I mean, given the destructive nature of pretrial detention on a person's long, the cycle of recidivism and whatnot, and particularly because there is a caveat, if it's clear that a person is endangered, it doesn't seem, it just makes sense to me. I think we might get more pushback than we would on option B, but that certainly isn't a reason to not try.
Okay. And just as a member of this group, the fundamental is you're presumed innocent when you're charged. And imposing a cash bond is imposing a huge burden on people. And I think with this exception of the danger to another person or intimidation, there should be no cash bond. So I agree and with you all that option A. I would add that, for example, if someone is charged and they fail to appear, that will probably be a different topic at another time. So this is the initial charge when someone comes into a magistrate or a first appearance before the judge, that if the only charges they have are misdemeanors, they should be released with an order to appear back in court. So it sounds like we have, with the absence of Mr. Woodall, a unanimous agreement on presenting to the task force option A.
Representative Maury, it's Josh with a question.
Yes, sir.
the second bullet under 2, should that be or and? We want the court to make an individualized determination that the person can afford to pay the bond and that it's necessary because there's no alternative condition of release. Or, I mean, because
I can jump in.
is it supposed to be an or an and? I'm having trouble.
Attorney General, I think it should be that there are written findings either way.
Okay.
Oh, no. It's supposed to be that you have to write it down if you want to give someone a secured bond. Written reasons for secured bond.
Okay.
But if you decide a secured bond is not necessary, then you don't have to write anything down.
So explain to me the relevance of my ability to pay the bond. So if it's $1,000 and they know I can pay the bond, they don't have to provide written findings that I'm a flight risk.
No, that written finding should be moved up higher. You have to put written findings down whenever you impose a secured bond, because written findings would be that the person could afford to pay the bond, or
what's the issue about the determination about the ability to pay? I mean, what if I engaged in a violent crime and I've said out loud, I'm going to go take care of the witnesses. What does it matter whether I can afford the bond or not?
Well, that's why the or is correct. So you have to either be able to pay it, or you have the findings that this person is too dangerous to be released. So you can detain for either one. You could detain even if they can't afford to pay.
I see.
So that the or is correct, but the written finding should come sooner. There should be written findings either that a person can afford to pay, or we have to detain them anyway.
Okay. I think I understand now. Sorry for the delay.
Not at all, but I think we could reword that a little bit.
Mm-hmm.
Yeah, to make it more clear. Thank you, Attorney General. That's a great point. Anyone else have any questions, issues? For those who are listening or haven't been listening, I think this option A, which we're embracing, along with all the other consensus points in our bail pretrial release, are absolutely phenomenal. They're significant. We've had people sit in jail for weeks on misdemeanors. There has been no right to counsel, and this really prevents that from happening. We have in here that everyone who is in jail should have it within 48 hours of a magistrate's decision on anything, the right to come in for an appearance in court with the assignment of counsel. New things on failure to appears. One of this that we have in court, people miss their ride. The court doors are closed because the courtroom is packed. That to be much more forgiving if someone fails to appear. And if they provide notice 20 days to a clerk, there can be an automatic strike of a failure to appear and set a new court date. The suspension of the driver's licenses affects thousands of people on their first failure to appear on a civil revocation. There's a court system reminder to have AOC do more to remind people, just like the dentist office does, of your upcoming court date, so people won't inadvertently miss a court date. So I think there's a lot of great substance to this besides what you're just seeing on the screen. I do want to ask Natalia and the others, I think we mentioned it once before, North Carolina is one of, I think, 26 states that allows a citizen to come into the magistrate and take out criminal charges against another citizen. So these are called citizen-initiated charges. Many states prohibit that if you break the law or it's a crime, law enforcement is involved and it's a crime against the state, and law enforcement handles that before processing a criminal charge. I think I made a recommendation, or we briefly discussed it. consideration that North Carolina eliminate these citizen-initiated charges. We have a law student, Bradley Anderton, who is sent to our SharePoint, or it will be there soon, a well-researched document on citizen-initiated warrants and the recommendation to abolish them in North Carolina. That if people have grievances, it can be a civil case, or if they have grievances that rise to the point more than a minor irritation, they do contact law enforcement and have them investigate and determine whether or not to bring a charge. But I was very persuaded by his report, and I would just make that one other recommendation for our work group, to have North Carolina eliminate any civilian initiated charges, misdemeanor charges.
Do people have thoughts on that now and moving forward with that, or would you like to spend some time reviewing materials and vote on it next time?
No, I agree with Representative Moore. Again, it sounds like a lot of folks just oftentimes go out and pull those charges out without having law enforcement involvement. And a lot of them can be usually solved outside of the court system anyways. So if it was a much more serious issue, then of course law enforcement could have gone and pulled these charges themselves. So I think that's a necessary reform that we can make, and also helps save resources of the state when it comes to tax dollars, and our prosecutors are already overworked and overburdened. I'm sure there's other alternatives that folks can find instead of private warrant courtrooms.
And I will add, while I was in Durham, we initiated what we call a people's court because we had so many citizen-initiated warrants. I cannot give you the racial inequities by data, but I can tell you what I saw in these courtrooms. There was racial inequities on who was brought into court by a disgruntled neighbor or a shop owner or something. And I think if we followed, 24 other states that do not allow this, that you have to use law enforcement to initiate a criminal charge, it would help reduce people accumulating a criminal record, even if it's dismissed. So, but happy to hear from Commissioner Tara, or if Mr. Woodall's on the line.
I completely support that. I think if we're discussing preventing local municipalities from creating criminal ordinances, we certainly should be concerned about individual citizens having that authority.
I agree with that because I know that many times citizens, a lot of time is not even, they may bring charges not even with the issue that's at hand. It's something that may have happened some time ago, and this animosity continue to build up, and they know they have that option, and they exercise that option, and even in some cases, after the individual go ahead and initiate the criminal charge, then after they think about it for a couple of days, they want to reverse it. So, the money's been used by the state and what have you. So I support this issue.
Okay, thank you.
Great. So having consensus on option A, we'll move forward with that, with the wordsmithing change about the providing written findings. There's also a reference in that recommendation to citizen-initiated warrants, so we'll strike that section. And by consensus, this group has also approved the elimination of citizen-initiated warrants. So those will both move forward to the full task force. So next, you also received a recommendation on decriminalization. So in the past, we talked about the criminal code, the need for further study on it. And I think kind of one of the decision points we have here with this recommendation, I have heard working group members express an interest in decriminalizing all class 3 misdemeanors or a subset of class 3 misdemeanors. And in this recommendation, in the one that you received, there is a subset of offenses, and I can pull that one up. So that's kind of the first decision point. And then, either way with that, we can couple that with further study of that issue. And also in the recommendation you received, there's some discussion of appointment of counsel. So let me know what's most helpful. I can pull up the full text of that recommendation, or if you all want to start off with that question of kind of what threshold you want to use for decriminalization.
So I support changing these class 3 misdemeanors to infractions. I mean, oftentimes, Representative Mori, you know this, the General Assembly already has removed the right to counsel on some of these class 3 misdemeanors as well. And a lot of them are public urination. I mean, the poverty crimes, soliciting alms, things of that nature. Again, there's other ways to go about doing it. And again, I remember Professor Smith's presentation as well had a number of these particular misdemeanors as a reason for so many criminal charges and so many interactions with law enforcement that people have. Again, it's another racial equity issue as well. It's essentially criminalizing poverty. So I would more than welcome reforming that and making those into infractions if we can.
Representative Maury, looking at some of the, I looked at some of the solutions and some of the issues when we talk about public urinization, talk about sleeping in the parks and things like that. And I remember back looking at some of these data that was given to us early on, and a lot of those type of charges were right at the top of the number of charges that we deal with each year. And I support, taking a great look at decriminalizing these particular issues.
Okay, thank you. And so, Commissioner, you agree all class 3 misdemeanors would be removed as criminal offenses and perhaps civil or infractions?
Yes, ma'am.
Thank you, sir. Tara.
So I had the SBI Advisory Committee on Law Enforcement Use of Legal Force meeting yesterday, and we were going through our recommendations. And one of the things that the Chief of Police from Winston-Salem flagged as a concern for her was that we as a society have gotten to the point that we call law enforcement for everything. And law enforcement has the authority to use force to compel whatever, to solve whatever, come to whatever resolution needed. But that calling them for everything makes it more likely that there could be an appropriate use of force. And so decriminalizing or making these civil seems like both an important step in terms of, just the criminal justice system, but also responding to the instances of law enforcement use of lethal force. So I agree.
Great. There was something on the handout that Natalia sent us that it came up eliminating the nonviolent class 3 misdemeanors that do not improve safety except for offenses issued on the emergency powers conferred in Chapter 166A. I think that was a little bit of our discussion, and if someone, I think Mr. Woodall had something about the emergency powers. I can't think of what offenses those are that would be charged as a class 3. Failing to disperse. Do you know, Senator, is that a class 3 misdemeanor, failed to disperse?
I think failure to disperse is a class 1, I believe. I mean, I'd have to look at that.
Representative Maury, I think that might have been speaking to like executive orders related to COVID or things like that.
Well, that's a whole different issue. It's not much enforcement.
Yeah, I think it was intended to address those types of issues.
Okay.
That exception.
So I think I would allow for that exception under anything that is, any offense issued under the emergency power conferred in Chapter 166A. Does that make sense? I mean, if we are talking COVID, we are talking about masks. If we're talking about some of these things that could be interpreted.
Yeah, Representative Murray, for me, I'm thinking again with all these class 3 misdemeanors, if we're criminalizing them, I think it's best to approach them all as infractions in general. So I think a lot of them come with, other factors that individuals are potentially dealing with, whether it's substance abuse, poverty, mental health issues, that could be leading them to make whatever decisions that they're making. And I think the best way to handle those all would be civilly. That's just my thoughts. Would love to hear from the rest of the group.
I just wanted to provide a little more context on, we had a lot of conversations with various stakeholders about why this might be a good carve out. In addition to kind of the executive order piece, there was some thought that if you make certain things a crime for businesses in particular, people will just see it as the cost of doing business and they'll pay the fine. And so there were a couple of examples we were given where sort of social justice type requirements under criminal law could be flouted if they were civil. For example, requirements on landlords to make housing habitable. If that's just a civil charge, then they'll just pay the fine because it's cheaper than making the repairs. So that is how it came up in the context of the local ordinance. Whether that moves you in the same way for this issue. I just raised that was something that was brought to our attention, that sometimes you need to be able to make things criminal because people will just pay the fine and do the behavior anyway. I don't think that rationale applies to the vast majority of the types of things that you all are talking about, but that's the issue.
Representative Maury, as somebody who hadn't done his homework, I hadn't read all the different crimes to which this applies. I can tell you that I would feel much more comfortable if there were a thorough process, which included people who spend their lives dealing with these crimes, whether it's prosecutors, district attorney, public defenders, justice involved individuals, kind of going through them one by one. Like, I'm completely on board with the principle that we criminalize too many things and that infractions can deal with most of them. But the idea that we would just wipe out all of them without a very individualized analysis would give me some pause.
I think part of the recommendation, and Natalia may have it, that we were asking that the General Statutes Commission undertake an ongoing review to study the criminal code and make further recommendations. I think the option 2 to removing all class 3 misdemeanors is we got a subset that I think Jesse Smith provided. We had like almost 11,000 class 3 misdemeanors charged last year. Only 20% ever had a conviction, but that means 8,000 people got a charge and then just dismissed, but still have a criminal charge. But there is a list of, public urination, sleeping in a public place, consuming beer in a public place, an open container, begging, failure to pay fare, return rental property. If we wanted to carve out and recommend those became civil infractions, and then also recommend that the General Statutes Commission undertake this study, would that be more palatable or less?
I think that would make a big difference.
Just as long as somebody's done an individualized analysis of each charge, like rather than a whole class, because there could be some class 3 misdemeanors that should be crimes.
So again, for me, as far as seeing our work on this task force, again, I see it as a type of guiding force in helping us, change the trajectory and direction of our state when it comes to racial equity issues. And that's part of the reason why I'm looking at these class 3s as infractions to begin that conversation. Obviously, we're not the ones who are going to get these immediately passed, and it's not going to be the law of our state tomorrow. But making sure in a way, however we do it, that we're encouraging that, whether it's a review with the General Statutes Commission, like you talked about, Representative Moore. But I think there should be some sort of recommendation from our task force that's talking about how we need to change these class 3 misdemeanors that are essentially criminalizing poverty, mental health, substance abuse, things of that nature, into an infraction instead of pushing people through the criminal justice system.
And one piece of additional context I can provide. So I know we've talked a lot about some of the ordinances, which are class 3 misdemeanors, but this conversation also really dovetails into the last conversation we're going to have about marijuana, because actually the number 1 charged class 3 misdemeanor is possession of marijuana under 1/2 of an ounce, followed by possession of drug paraphernalia. So those are, charged at a rate of over 30,000 times per year. So this conversation is very closely linked to the marijuana conversation that we're going to have soon.
Can I ask if Ellen's on? I just got a text from Jim Woodall that he's online, but he may be muted. He may want to say something.
I just gave him the ability to talk. Sounds extreme, but I just changed his position in the Zoom.
Jim, are you there?
Asked to unmute. Maybe that helps.
He thinks he's muted.
Let me work on that. Hold on one sec.
I think I just was unmuted.
You're there. Hi, Jim.
Great.
Okay. Okay. I'm following along. I just wanted to get unmuted. Okay.
Is there anything you would like to say about the decriminalization of class 3 misdemeanors?
Not at this point. I apologize, but I literally was just able to get on about 30 seconds ago.
And Ellen is actually going to pull up a list of the highest charged class 3 misdemeanors to help us in our discussion.
And while she's doing that, I also wanted to, I don't think the group has seen the list that was put together, but that also, like, there was some data crunching done on that initial list as well. Was it, Natalia, remind me if it was that these are the ones with the largest disparity? Those were the ones with the largest disparity in charging. So the list and the proposed recommendation had some basis as well.
Yeah, that's right. And I have a chart that I can also pull up for that. So, the more limited set, those were not randomly chosen. Amisha from DOJ worked on that list, and she coordinated with Professor Baumgartner at UNC. And he did an analysis, based on a subset of charges. He looked at which ones had the highest rate of disproportionality.
So you can see here in this list that I put together, it's both traffic and non-traffic misdemeanors. I've at least gone as far as fleshing out, I think, any charge, and I can send this around to you guys. The larger description of the charge for anything above, I think, 300 charges a year. I mean, it was last year, to be clear. This is from the tally report from 2019. I'm just scrolling. Tell me if at any point you want me to pause or move back up.
Ellen, is there any way for you to rank that Excel sheet?
Yeah, sure.
From the number? Well, not like that. Is it like, I think N is the number of total charges? Is there any way you can sort it?
It's ranked already. Sorry, to be clear.
Oh, okay.
It's already sorted.
It's already sorted. Okay. Okay.
Yeah.
Thank you.
Yeah.
Jim, are you able to listen? What's your thought on speeding? Like, speeding clearly is a driving infraction, but if somebody's driving 30 miles over the speed limit on a 2-lane road, they could be putting people's lives in danger. So is 15 miles above the right line, or what do you think?
Yeah, and can you hear me now? I'm not using my video because I got low bandwidth, but can you guys hear me?
Yeah.
Yeah, I do think on speeding there we should have some consideration of the amount over the speed limit, because just like here in my district we have certain rules. There are some speeding charges that we don't even reduce because we feel like they are so high that they are a danger per se. For instance, going more than 100 miles per hour. And then, if you're going 65 down Franklin Street, which is a 20-mile-per-hour speed limit in the 100 block, that falls in the same category for us. So I do think there are some traffic offenses we probably need to take a little bit better look at.
Could I suggest, so we don't get bogged down too much, that if we had a recommendation to the task force to reclassify all class 3 misdemeanors that do not pose a risk to public safety or affect an emergency power, and have this General Statute Study Commission do a further report, that we come out that we are wanting these reclassified if it doesn't pose a risk, if it's not speeding on a 2-lane road, or if it's not, illegally evicting a tenant. But the non-victimless crimes, sleeping in a park, trespass, peeing in public, things like that.
I support that. I think it's the best way to do it.
Would that be acceptable as a compromise?
Yeah, I think so.
Representative Maury, can I just add one other point for the group's consideration? I think in the draft that went out, there was one other idea that might not have been in an earlier version, and that was to also study as a part of this, the moving of traffic offenses to the to be administrative. So that's a separate study item in addition to the general code study.
Yeah, thank you. So that would be Part B. Study should include the implications of moving traffic offenses from the criminal to the administrative code.
Yeah, and I think, that's something, and I may have said this to the group before, and I would actually support that being studied, but the biggest pushback you get from that are from rural attorneys in rural areas who make a lot of money on traffic court, and they feel like if it isn't in the court system, that it can cost them money, that people will try to deal with it themselves. So that's one of the places you'll get a big pushback on that.
That's okay.
Oh yeah, no, I agree. That's where we always get the pushback.
More than okay. Don't want our state to be bankrolling people.
Well, and I think what Senator Mohammed said, once the General Assembly said anyone charged with a class 3 misdemeanor no longer can have the right to counsel, that was very troublesome.
Yeah. No, I agree with all that. I was just trying to let people know the objection to that always comes from a place that I'm not expecting, and that's where it's come from in the past.
Right. Okay, thanks.
Sorry, I'm sorry. That reminded me of one more piece. I think it also said that while waiting, if they're not decriminalized, then people should have the right to counsel restored. For anything that remains criminal, people should have the right to counsel, and IDS should be appropriately funded in order to do that. Am I making that up, Natalia? Did it say that?
I think you're right, Jasmine, that did come up as a recommendation.
Okay.
Yeah, that's right. Sorry, I was having trouble unmuting.
Okay,
Okay, so it sounds like we have consensus on kind of amending that decrim recommendation and meeting somewhat in the middle, where we'll recommend the further study and decriminalization of class 3 misdemeanors, but with an eye towards making an exception on those that would impact public safety. So I'm going to share my screen one more time. And, the next thing that I want to do is check in with you all about if there are things that you feel like we have not covered. So just in doing that, up on the screen is a recap of what we've already passed. So we started off with the recommendation that the AOC should include racial data in reporting. We recommended racial equity training for all court system personnel. We had the local ordinance sunset provision. We recommended supporting greater use of post-arrest diversion and citation and arrest. And then we made 3 juvenile justice recommendations around raising the minimum age of juvenile court jurisdiction to 12, requiring that a school-based petition require the signature of a school administrator or social worker, and then allowing prosecutors to have the discretion to accept pleas in juvenile court for class A through G felonies. Those have all already been passed by the task force. We've also, out of this working group, released our juvenile life without parole recommendations, and those will be ready for the task force to vote on at an upcoming meeting. So, next up we have only one more meeting. At that meeting, we'll focus on marijuana, but we'll also reserve 15 minutes or so for Jim to go over a recommendation around prosecutorial ethics and charging decisions. So with all of that being said, I wanted to open it up first to members of the working group, and then second to any of our other staff or our co-chairs to just raise if you have anything that you feel like falls under our group that we haven't covered yet.
Could I ask, Tara sent a great email, and I think it's really important point, and it may be more working group 4 or ours, but it's about people that are serving prison time. And Tara, correct me if I'm wrong, but they're about ready to be released, but they have some, charges in other county courthouses where there still is an order for arrest, or there's an infraction, or there's speeding tickets. So these people have spent, maybe months, maybe years in prison, and upon their release, they're swept up again because of an unresolved issue that was years ago in a county courthouse. But Tara, do you want to expound on that and how we might fix that issue or have a recommendation?
I will defer to Natalia and Jasmine because I know they've been working much more closely on it than I have. I just wanted to pass it along because Daniel flagged it, but I know they've both been working closely.
Yeah, I mean, it's definitely an important issue, and I appreciate any and all encouragement, but I am personally taking it up and working on it. So I do think we have a plan in place whereby DPS is going to be providing a list of people who are scheduled to be released in some subset of time in the future, say like the next 3 years. And then DIT is going to work on a data match, which will pull all of those pending charges for those folks. And then AOC, as part of their existing data integrity project, has agreed, I think, that they will take up this project of sending that information to local district attorneys who can then use their own criteria to initiate mass relief for old and or minor pending charges. And it's definitely important because some of those charges can prevent or delay people from getting out of prison.
And working group 4 does have a companion recommendation. How much of it may be mooted, we'll have to see. but I think, they'll at the minimum be something that speaks to the importance of not having these pending charges hanging over folks' heads as they're being released.
Could I also ask, our last meeting, we had really interesting presentations on the Victim Compensation Fund and how to make that more available to people, the restorative justice proposals. Were we going to try and propose any recommendations on that?
Yeah, thank you for mentioning that. So I was worried that we were going to have too much to talk about today and we were going to run out of time. So that's why I used the survey for those. And we did get consensus on moving all of those out. It wasn't unanimous. So I don't know. I don't want to put Jim on the spot, but I don't know if he wants to speak specifically to some of the issues with the Victim Compensation Fund, but welcome any discussion on those recommendations.
Yeah, I think there was only one thing that I'm trying to remember. There was only one item that I brought up in that. I think I agreed with everything except one, and I don't remember this exactly what it was right now.
Yeah, so we had them divided out, and there was one about the Victim Compensation Fund and some specific steps, including eliminating the need for a law enforcement report to be filed and eliminating the denial of claims based on, victim's decision not to cooperate and the criminal activity by a victim.
Right. I remember now. And my general concern was just that I thought that might be a little bit broad, because I do think sometimes there's criminal activity or that should disqualify people in some situations. They may be, that may be a small number of cases, but I don't think that we should just eliminate that as a consideration or recommend that it be eliminated.
Do you have any thoughts, or do you want to give some thought if there is a way to kind of narrow that or tweak it to strike that balance?
Oh, gee, as far as wording, I really don't. I just felt like that was a little bit too all-encompassing, because, there are situations where even though a person is, ultimately the victim of a crime, they've made some decisions that were really poor and that were criminal in nature. I didn't think we were going to talk about this. I'll have to look at it.
Yep, totally fine. Sorry to put you on the spot.
No, that's okay.
So do our co-chairs or any of the staff have any other things to flag for us of issues that we haven't covered that you feel like we should? All right. Jasmine, did you just unmute?
Yes, I think the only thing that I would add is what I guess you already said it, that next week y'all will be talking about charging decisions, and that's one of the executive order issue areas. And so to the extent there are things to cover there, come prepared.
Don't forget marijuana.
And marijuana, don't forget marijuana. I think the Attorney General lost his audio, but just texted me that he didn't have anything else to add.
Justice Earls, do you have anything you would like to add if you're there?
So I don't have an issue to add. I do have a hope you'll I feel like as a task force, we haven't fully wrestled with the whole issue of SROs in schools, and so the contribution that that plays in the juvenile justice system. So I guess I want to just flag for you that we continue to need your input on that.
We did, one of the recommendations is the SRO cannot take out the charges without, so that if we still need to look at other issues with that, and especially as we looked at juvenile justice and rethink of other recommendations.
So I was thinking of the more broad issue of, should there be a recommendation that it is not a good practice to have SROs in elementary schools, for example, or as part of the reimagining, even bigger picture, reimagining public safety, does the presence of police officers in our public schools mitigate against what the community perceives as what makes them safe? And so, there's certainly some on the task force, some community representatives who want to consider whether there should be a recommendation that we move away from having SROs in public schools altogether. So.
I've got a question. Have any of the working groups I feel like it's this group, not working group 3, but this task force, because I'm on a number of task forces right now and working with a number of groups around all these issues. And there's been some discussion in one of the groups about looking at SROs, the policing type of work they do sometimes in the schools versus the safety that they can provide in schools. Because, in my district, I had a school shooting that was stopped by an SRO, a young man who murdered his father, shot him 7 times, came with pipe bombs and an AR-15 to the local high school and was confronted by the SRO, and lives were saved. I don't know how many lives were saved, but lives were saved. Confronted by an SRO, and it just so happened that the driver's ed teacher was a former state highway patrol trooper, and he helped out too. So, even in the elementary schools, I can't turn a blind eye to that. I felt like we had students saved, lives saved, because we had an SRO who confronted that young man. And I just want to make sure we consider that and talk about that, as well as the data that may show there are a lot of juvenile charges that come out of having SROs in schools. Because I think that safety factor, at least at Orange High School in Hillsborough, North Carolina in 2008, was huge.
Jim, this is Josh. There was a similar story in Greensboro where an SRO intervened before a shooting occurred. And, obviously those don't get the same news because the right thing happened. And it's a wonderful thing that the right thing happened. I mean, there are other ways to deal with the problem of too many kids being brought into the criminal justice system. One of which is this group's already recommended, which says that you got to be 12 before you can even get a criminal charge. But others are that I can't remember if it was this working group or another working group, that a social worker or school principal has to co-sign before any SRO can bring a criminal charge. So it's not just some SRO who is too rigid in their notion of responsibility. So I think there may be other ways to deal with it other than just getting rid of them altogether.
And I think I was only trying to flag that this is going to come up for the whole task force. And so folks on some of the other working groups who may not appreciate the impact of what you all have already recommended on what they're considering. So I'm just saying it's something that you all need to be engaged in the discussion on. That's all.
Great, thank you. And I think it was very helpful when Billy Lassiter came and showed us, 40% of these juvenile petitions were coming from schools and SROs. And what is the role? Is it protecting the building and the safety from an outside threat? I think we talked about, rather than bringing children into a criminal prosecution.
Yeah, but he also told us that they have some data that shows schools now with SROs, they are having fewer children brought into the criminal justice system. And he said they hadn't looked closely enough at that to know what it means. So, I do think it's a big concern how SROs are used in the schools, but I think it's something we need to be very, very cautious about, because I do think they create a level of safety. And I know one of the schools here locally, and I can only go by my own experience, I know how much the kids love that SRO at one of our local elementary schools, and he's a great role model and he helps those kids. So I think it's something we really got to look at.
And DA Woodall, I mean, for me, as far as SROs, excuse me, I think that's exactly where it needs to be. Was we need to have that discussion where SROs need to get back to the basics, where they're we've talked about it many times on these Zoom calls, where police officers are more guardian, they're protective, so they're stopping that school shooting instead of being the gateway for that school to prison pipeline. So I think we can come and strike a good balance where they're also building trust with the community, with young people at an early age, with law enforcement. So I just think that's where we should hopefully at a task force look at getting law enforcement back to as being a safety net and protector in our community, and working with our young people and building those positive relationships early on.
I agree with you completely.
Great. Any other remarks today before we adjourn? I think we made a lot of progress on a number of issues that we'll be able to move forward to the full task force.
And if something comes up, we will still entertain it, and I'm sure keep your thinking hats on. I thank you all so much, and Natalia, for putting together the PowerPoint and the language. Really appreciate all the work that you've done, Ellen done, Jasmine's done. And Ashante and Karen, thank you for being here. If you have anything you'd like to add or say.
Thanks, everyone. And just stay tuned. Our last meeting is November 10th. It's a Tuesday instead of a Wednesday. And we'll probably need to add a little bit of extra time, so it might be a little bit longer, to make sure we're able to thoroughly go through our marijuana recommendation. We have a couple national experts who are going to come speak to us. I think it's going to be really interesting, as well as our prosecutorial recommendation.
Okay,
Sounds good, and I'm sorry I couldn't do that today.
that's fine, Jim.
Thank you, Jim.